We're talking about hot topics in benefits, and believe it or not, we do not think that that is an oxymoron. There are some interesting topics that we wanted to bring to your attention today, just at the end. And to help me do that, I have two of my colleagues. I have Hallie Fistler. He's to my left, and many of you have already worked with Hallie and probably seen her at this seminar in past years. And we have a new addition to our group, and we're really happy that Hallie Goodman is here. She's an associate with us. She is not related to Tim Goodman. But obviously, if your last name is Goodman, you have a better chance of getting hired here. Anyway, so I will tell you that Hallie and Hallie are going to be doing the heavy lifting in this particular panel, and we're going to be talking about some really difficult things like mental health parity and voluntary benefits. And I will let Hallie take it away.
Yeah, so good morning. I think, yes, it's still morning. As Liz mentioned, we're going to start off with our favorite topic, which is mental health parity. It's something I'm sure you, in living in the benefits world, have heard a lot of different panels about it, and there's been sort of a lot of talk since the Affordable Care Act, obviously, because it amended the rules regarding mental health parity. And I'm not going to do an exhaustive survey today. I'm going to be focusing on what the enforcement efforts have been in the recent years and sort of where the violations have been found and some new FAQs that have been released. But before I really get into that, as sort of a background reminder, so mental health parity, basically, so if a group health plan provides medical or surgical benefits, and it also provides mental health or substance use disorder benefits, then the plan's usually subject to parity, which means that broadly speaking, the coverage has to be the same for those two benefits. So it's not a principle that says that you have to cover all mental health benefits or substance use disorder benefits, but if you do, it has to be the same. And there are three main ways that that parity has to exist. One would be annual or lifetime limits, which is pretty straightforward. Then we have financial requirements and quantitative treatment limitations. And there we're talking about deductibles, co-pays, co-insurance, the number of treatments or visits to the doctor that will be covered. And then the third one, which is what I'm going to be focusing on today, is the non-quantitative treatment limitations, which, I mean, when I first read that, I was like, okay, what does that mean? It's not exactly clear. So as we get into that, I wanted to talk about the enforcement efforts. So in 2017, the Employee Benefits Security Administration closed 347 investigations. Of those, 187 plans were covered by mental health parity, and 92 had violations related to mental health parity. And so to give you an idea, that's 50% of the plans they looked at had a violation. And if you look at the breakdown of the violations, 48.91% relate to that non-quantitative treatment limitation. And when I look back on 2016 and 2015, it was the same. It was about 50% of the violations were in that area. So clearly that's where people have the most trouble complying with mental health parity. And so in reaction to this, a joint effort with Treasury, HHS, and the Department of Labor, they've released both FAQs and an action plan of what kind of steps they're going to do to kind of release more information to help people comply with mental health parity requirements. So they first released some proposed FAQs just in April, and as I mentioned, the three different departments working on them, and they were looking for public comments by June 22nd. And reflecting those enforcement efforts, they really focus mostly on the non-quantitative treatment limitations. There's a little bit on the FAQs as well about disclosure requirements. So a non-quantitative treatment limitation, since that's the focus of the FAQs, I'm going to talk about that the most. The rule is that a group health plan or health insurance issuer may not impose a non-quantitative treatment limitation with respect to mental health or substance use disorder in any classification unless, under the terms of the plan or insurance coverage as written and in operation, any processes, strategies, evidentiary standards, or other factors used in applying the non-quantitative treatment limitation to mental health or substance use disorder benefits in the classification are comparable to and are applied no more stringently than the process strategies, evidentiary standards, or other factors used in applying the limitation to medical surgical benefits in the same classification. So as you can tell, that's kind of a mouthful. Like, it's not easy to really pick apart what each of those things mean. Broadly, if you think about what the other two standards were, when we're talking about copays or deductibles, non-quantitative treatment limitations really have to do with the scope or duration of benefits. And what it's really saying here is that when you're developing what you're going to cover, the factors you use and the factors and the scope basically have to be the same for mental health benefits, substance use disorders, and for surgical medical benefits. I was wondering when I looked at this why it's not just called a qualitative treatment limitation. And the reason I think they did that when I kind of dug in a little bit more is that usually the standards under this category are qualitative, but a lot of those qualitative standards are developed using numerical sources, right? So they use a lot of quantitative data, and I think that's why they didn't just call it a qualitative treatment limitation. So to kind of break down this a little bit further, I have some examples. These are areas addressed by the FAQs as particular areas where there's been violations and where people have a lot of trouble kind of sorting through what we're talking about here. So in this example, a plan denies treatment as experimental when no professionally recognized treatment guidelines define clinically appropriate standards of care for condition, and fewer than 2 randomized controlled trials are available to support treatment use with respect to the condition. The same plan defines autism spectrum disorder as a mental health condition. And I know that this is a little bit complicated too, because I know autism is one of those disorders that has multiple classifications. But the plan denied benefits to applied behavioral analysis therapy on the grounds that it was investigative or experimental. And even though that it's backed by 1 professionally recognized treatment guideline and more than 2 control randomized trials supports the use of that therapy. So the question is, does that violate the non-quantitative treatment limitation? It's like a tongue twister trying to say that over and over again. And the answer is no. So what I mentioned earlier about sort of when you're looking at the factors or you're looking at the sources, a medical management standard limitation or exclusion of benefits based on whether the treatment is experimental or investigative is an example of a non-quantitative treatment limitation that I think people often ignore. So that gets to sort of looking at sort of the sources of what they're using. So they're using different medical experts to say this treatment is experimental, this treatment is investigatory. So it gives you a little bit of an idea. And so here, because it falls in that category, it can't be applied any more stringently than it would be for medical surgical benefits. So the plan document was completely compliant in this case. It stated that they would be covered the same, but when they actually looked at the claims, they were not applied the same. And that's, I think, the big disconnect here. Yes, there's a question? Yeah.
I'm the ERISA attorney, and I don't really know what it's about either. So you're in an untenable position really as a sponsor. It's really, really hard, but the burden's on the plan. So.
Right. Have you guys seen? I mean, I think it's something that people continue to struggle with, which is why this is a center. I'm not sure people are doing a good job figuring this out. Have you had people successfully? Yeah, it's really about the documentation, right? So even though it's an extra cost.
To analyze how your TPA, like looking at it and be like, I don't even know what I'm looking at.
Yeah. I think one thing that I was looking at the compliance data too is that even though it's not sort of a per se violation when they look at sort of the categories and the amount of claims denied or not, they said that's usually the biggest red flag. So when they're going through the data, that's the first place they stop. Like if you see one that's like a 60% denial, and one that's 10, but it's under the same sort of category of factors, then that's kind of where they start, which I know isn't helpful for you on like the day-to-day basis, but I think it's kind of a way to kind of at least get the most egregious potential violations out of the way. Yeah, and one thing I should say is Not a lot of the plans, I think, were actually, a lot of them were just asked to comply and pay the claim. And that was a lot of the action. It wasn't the extreme excise taxes that can be, enforced. So I think there is that understanding here that they need to do better, right? That's why they're releasing the FAQs and the action plan, because there is still such a high level of violations. So going on to another example, which is about medications. The plan has chosen to determine what treatments they're gonna cover based on the Hayes Medical Technology Directory. And they said generally that they're not gonna cover anything that's rated below a B, but on a plan by, case-by-case basis, they will cover something rated with a C for medical surgical benefits, but they don't always do that, or they don't do it at all for the mental health or substance use disorder treatments. So again, is that something that's okay? And the answer is no, it's not, because the evidentiary standards there are the key. The evidentiary standards have to be the same. So this goes back to the doses limitations. And so basically, if you're gonna pick a professionally recognized treatment guideline, that guideline, if possible, has to be applied the same to both types of benefits. Which is, again, a little bit tricky, getting back to your question of like, how do you do that as a plan sponsor? And I think that is where sort of some of these, you can do your best efforts, but some of these consultants probably are gonna be helpful. I know bigger employers sometimes have pharmacy and therapeutics committees that determine how to cover prescriptions, but I think that's for the very large employers. And there again, it's just really about documenting what standards you're using, what factors you decided to use, and then making sure that they're applied the same for both types of benefits. So going the other direction, so this is a plan example where I think sometimes you get sort of in the weeds in this and you forget the bigger picture. And in this example, a health plan provides benefits for prescription drugs and medical surgical benefits and for mental health and substance use disorder benefits. But they just don't cover anything for bipolar disorder. And I think a lot of people think, okay, they get really into the parity thing and they forget that actually this is probably permissible, because the rule, again, does not require that you cover all bipolar, all mental health issues or disorders. And an exclusion of all benefits for that a particular condition is not barred by the mental health parity rules. That said, I mean, under state law, you're probably going to have to cover this, especially most states would, consider this essential health benefit. But under the mental health parity rules, it's not, again, that you have to cover everything. It's just that if you do, it has to be the same. Additional example, which I think comes up a lot, has to do with step therapy. And step therapy is basically the principle that you have to try a cheaper option first and show that hasn't been effective before you are covered for the more expensive treatment. And so in this case, a plan requires that a participant have 2 unsuccessful attempts at outpatient treatment in the past 12 months to be eligible for certain inpatient, in-network substance use disorder benefits. But the plan also requires only 1 unsuccessful attempt at an outpatient treatment in the past 12 months to be eligible for inpatient, in-network medical surgical benefits. So the reason I included this is because you look at it and you say, okay, you're comparing these next to each other, they're not identical, so it probably is not okay. But in reality, it might be. So on its face, it appears to be more stringent for the substance use disorder benefits, but in reality, it might not be. What you just need to demonstrate is that the evidentiary standards or other factors are comparable. And that's really a facts and circumstances investigation, which is not easy, obviously, but is a good example that you do need to take the time to actually do this analysis. You can't just kind of look at data and do a quick comparison. And this includes another issue, is that the facility types is an area where there's a lot of non-quantitative treatment limitation violations. So also addressed by the FAQs of the area that people are getting confused with has to do with reimbursement rates for non-physician practitioners, so probably like nurse practitioners, for example. And that is another area where it has to be the same. provider reimbursement rates don't have to be identical dollar for dollar. But again, it's about the standards and the factors that you choose. They have to be comparable, and you have to document how and why they are comparable. Another thing to keep in mind is certain states have different requirements that apply to medical and surgical benefits. So for example, a lot of states, or at least most, have to comply with certain state or federal network adequacy standards. And a lot of times the way those are written, they're written so that they only apply to medical benefits, but because you're covering them for surgical benefits and medical benefits, you end up having to cover them for mental health benefits as well. So it's something to keep in mind. I think that's one that kind of gets under the radar that people don't really think about, but is important. Another area that I think is a common violation is just the disclosure requirements, and particularly the medical necessity determinations that have to be disclosed under ERISA. So determinations with respect to the mental health and substance use disorder benefits must be made available by the plan administrator or health insurer to any current or potential participant, beneficiary, or provider when requested. And it has to have the same information that you would have for the medical or surgical benefits, which includes the reason for the denial, but it also has to be within the 30 days of the request as required under ERISA. And it also, other requirements to keep in mind if you have an SPD and you're providing certain information related to the list of providers or what's covered, you need to also consider that in parity. So whenever you have a notice, you need to consider whether it falls under this and whether you need to include information about the mental health or substance use disorder benefits.
So Hallie, it seems to me that, this is an evolving area of the law. And just as when we had ACA reporting for the first time, we had consultants and providers there to help you with ACA reporting. It sounds to me like this is maybe a new area for some consultants to get into to help you all figure out whether or not you're compliant with this particular law, because it's very confusing, as you were saying. And it's pretty opaque, I think, in terms of the information that you get back. So we'll see, I guess, what will happen in that particular space.
I mean, yeah, I think there'll be a growth of that. I think it'll be interesting in sort of the action plan. When I took a look at it, there was a number of additional guidance, and I think in this environment, we know that a lot of the guidance isn't really coming out. It's being delayed. So it'll be interesting to see, because then it makes me wonder if there'll actually continue to be as much, enforcement as there has been. But I do think it's a space where consultants, we will probably see more consultants, especially as people are kind of getting the ACA reporting under their belt and sort of figuring that out. We might see that in that space, so. Yep.
Are you saying that there's been any pushback on regulations or enforcement in the new administration? We keep hearing about regulations going away. It seems like this is an area that is seeing more regulation.
Yeah, I think it's the anti-regulatory environment is counterbalanced by the publicity around sort of the opioid crisis, which I cannot say that word ever, but just, the concerns about that and what actions. So that has really been the focus, I think. So they can say, hey, look, this law is protecting that, making sure that people are getting the treatment they need for drug addiction. And so that's why I think this is an exception to that kind of anti-rule.
And I think I would also add that even though you would think that maybe in this administration we would see fewer Department of Labor audits or IRS audits, that's not been my case. I have seen probably more, I think our practice group has seen more now than we ever have. And so I'm not entirely sure what that's about. Maybe, in terms of being able to get penalties, there's some revenue that's coming back to the federal government, but you would think that that wouldn't be happening, but it is.
The messages are.
Yeah.
And then my last question is, there something we should be asking of our TPAs that we're not asking for that would help us here? I mean, can we hold them accountable? Should we be looking at special languages, or just something that we can, short of paying money for a third party, making them more accountable to help with this process of parity and managing claims and giving us data so we know at least they're doing what they told us they were going to do in terms of managing the parity issue?
Yeah, I mean, have you seen employers push back on this? I mean, it's hard to obviously, negotiating with any TPA is always challenging, and what they'll give you and what they'll change. But
I haven't seen anything specific.
I
on
haven't
mental
seen
health
anything
parity.
specific either. Yes, Stacy?
I was just gonna say, my experience is they'll tell you, send you an email, and yes, you're fine. And then you have to decide how comfortable you are relying on that. And then, I mean, the other side of the contract, expectation is that you get into the contract, they're going to say, well, you're responsible for compliance.
Yeah, that's also, I would echo that as well and say that it's probably a contract issue. I mean, it's something to consider if you're doing an RFP, to think about.
Well, in indemnification language.
I was just thinking in terms of data that you can request that would make you have to prove it.
Yeah,
Just as you would have a third party going to do a claims review, they would give you data. Can a TPA give you similar data that you could at least give a look at to see if there's some highbrow things that would tell you if you wanted to get deeper?
yeah, no, I think so, and they should be able to. I think it's a matter more if they will. So.
Okay.
So I know that it's clear as mud. That's the conclusion of that section, I guess, but hopefully in the next year or two, we'll see a little more guidance. The FAQs, those examples are specific examples, but they provide some guidance, I think that is helpful in sort of those subcategories. The other thing that I guess I'm just briefly going to talk about is a brief wellness update. I'm sure, again, sort of like mental health parity, it's been something that's been talked about a lot in the last couple of years. And it's been one of those areas where there's so much conflicting guidance that people don't really know what to do. So I just wanted to update that, and maybe, I don't think this was covered this morning, but the wellness regulations were vacated, and it's effective January 1st, 2019. And basically the claim was that the EOC still has not sufficiently explained how the 30% cost threshold is actually voluntary. And so it was a case brought by the EARP, and the court vacated the rule and sent them back to the EOC regulatory agenda and ordered that new proposed rules be issued by August 31st. Now, in March of 2018, the EOC released sort of a status update on where they were on the rules, and it was basically like, we've done nothing. So, so they said they have no plans to do anything either. And really, this is an area that it's being affected by the politics. So there has been a new chair of the EOC that's been appointed, but she's still awaiting confirmation, and there's no plans to confirm her. I think it's going to depend on the midterm elections. So I don't think we'd see any action until the fall, and after she's confirmed or not, and which she probably will be after the midterms. And then I'll see what rules they release for us next. So it's on to Hallie.
And just if you thought you were having enough fun with the mental health parity, we're going to dive into voluntary plans. And kind of the reason that this has become a hot topic is that, more and more these plans keep popping up as different options for employees. And sometimes it's just great to go back and take a refresher course on, what are voluntary plans? What are the rules we need to be looking at? And exactly where do these things fit? Now, voluntary plans can be known by many different names. Sometimes they're employee pay-all, or worksite benefits, or voluntary benefits, but the idea is that there are additional benefits beyond the self-insured benefits that employers can offer. Oftentimes, it's the employee that's paying 100% of the premiums, but it's just one additional service, one additional benefit the employer can bring to the table to say to employees, hey, we're taking care of you. This is something, you don't have to go out and look for this kind of coverage. We're making it available to you as an additional service. And it can really cover a wide variety of plans. And oftentimes, we don't even think of these as being potential voluntary plans because a lot of times we just make them subject to ERISA. But it can include anything from your dental and vision and EAP, but even beyond that to different types of critical illness and hospital indemnity and disease-specific coverage. A lot more employers have been looking into those specific types of coverage, primarily in the context of this movement towards more high-deductible health plans and the fact that employees are on the hook a little bit earlier for the costs of their medical benefits and coverage. So the idea is that by offering these types of insurance, they're actually permissible under Code Section 223 that are not going to make individuals ineligible for HSAs, which, this is great. We have an additional benefit. We're trying to provide additional coverage. The caveat on it is that it needs to, for some of these, they really need to be paying a fixed amount, or it has to be a disease-specific management kind of program. So they do need to be, carefully designed. But as you can see, voluntary plans start moving into all different areas. Getting back to voluntary plans, it can include things as basic as business travel insurance and prepaid legal services, all sorts of different plans. But the first thing to remember is that generally, your voluntary plans, when they're employee, even though they're employee pay all, are still going to be ERISA plans from the start. That's where they start. That's the nexus. They're still going to be an employee welfare benefit plan to the extent that they're maintained for the purposes of providing benefits for sickness and accident and disability, vacation, and the like. And by virtue of being ERISA plans, voluntary plans are also going to be, that are also group health plans, would also need to satisfy some of the group health plan mandates, where we're getting into HIPAA portability, Affordable Care Act, Cobra. But if you take a look at your voluntary plan and determine that it can fit into the safe harbor that's available under ERISA, there's a possibility that these plans are going to be actually exempted from the other mandates, from not only ERISA, but the other required notices and required practices. Now, the fun part comes in taking a look at the voluntary plan safe harbor. It's located under Labor Regulation Section 2510.3-1J. And this safe harbor has very specific requirements, and we're going to take a look at each one of them a little bit in depth here. Some of them are easier to satisfy than others. But the basic ground rules is that the program has to be offered by an insurer. There's no self-insurance permitted here. There cannot be any employer contributions. Employees have to participate voluntarily. The employer cannot endorse the program, and the employer still, though, is allowed to perform certain administrative functions, but really and truly not receive any types of compensation other than, basic reasonable reimbursements. For voluntary plans to fit into this safe harbor, now it looks like this is very easy to check the box, but each of these different items is really nuanced. The important thing to remember is that in order for voluntary plans to satisfy the safe harbor, it really comes down to strict compliance. Are you satisfying each requirement? Because if you miss a single requirement, this voluntary plan that you have outside of ERISA that you're not doing reporting on, all of a sudden falls back into the ERISA category, and that has certain challenges. So as we go through these different factors, I think it's important to point out that these factors have actually been further developed by case law and then ERISA opinion letters that have been issued by the Department of Labor over the years. Most of this is from cases where the employees are bringing suits against the insurer. Employers really are not included in these lawsuits. The employees are going to the insurer saying, I was entitled to benefits, I didn't receive the benefits. Where it gets interesting is that usually the employee is bringing suit under state insurance law, and it's the insurers who are saying, well, technically this is an ERISA plan. And the reason why there's been more beneficial treatment for the insurers to have the voluntary plan actually be an ERISA plan due to the fact that you can remove it to federal court, you're outside of some of the state law claims and different types of awards that you can receive, and there's attorney's fees rules that are built in as well. So it's much more favorable for the insurers for this to be an ERISA plan. It's a fascinating dynamic. But it doesn't leave employers with a lot of case law guidance as to what would happen if the employer were brought into the lawsuit. What it does do is give employers kind of an idea of things to watch for so that you can stay out of that fray and not have to worry about your plan being recategorized as or treated as an ERISA plan later down the road if you wish to keep it as a voluntary plan. So some of these categories are easier to satisfy than others. So voluntary participation, already that can be ticked off the list, provided that you are not requiring employees to enroll, and there's really no automatic enrollment. So basically, you leave it completely in the employee's hands. Do they want in? Do they want out? The second category also is rather easy to satisfy, and that's the no employer contributions. This means that employers cannot contribute towards the cost of premiums, and on the other end, just because you have your employees paying for it, you can't get around that requirement by saying, oh, and we'll reimburse you for the costs of those premiums later on. That's still considered, based on available guidance, to be an employer contribution. And there is no de minimis exception. Where there are some interesting areas is that there have been some courts, mostly 11th Circuit cases, which have said that the use of cafeteria plans to allow employees to pay their premiums could be considered to be an employer contribution. Well, the first question is, well, how could this be an employer contribution? It's all employee paid. The court's reasoning came down to the fact that by allowing employees to pay for these benefits on a tax-favored basis, they're actually getting a contribution. It costs them less. The employer is subsidizing a portion of their benefits because there's a portion of their pay that's not getting taxed. So it just depends on which circuit, which court, which judge, but that is definitely a factor.
So based on what you have seen, would you advise people to put in their cafeteria plans or not?
Ooh, that's a tough decision.
I know.
It's a tough decision. It's one of those ones where it's actually a case-by-case decision, looking at where your employees are, you know, what the relevant case law is in the circuit that you're in, and exactly how much of, how much of a discount are they getting on the premiums. If the premiums, say, are, $50 a month, is that really that much? But if the premiums are starting to get into a couple $100s a month, then, you might start thinking, well, there's a bit more materiality here. It's an excellent question.
So if you have employees in several different jurisdictions, that makes it even more difficult. And probably administratively, you'd want to handle it the same, I would guess, throughout your entire employee population.
Precisely. And two, with respect to cafeteria plans and offering benefits, it makes it easier as well to make sure that you're satisfying non-discrimination testing when you're applying the same type of premium payment rules across the board in your cafeteria plans. And just think, those were the easy factors. So plans that if employers want to keep their plans in the voluntary category, they also need to make sure that they are not performing anything beyond what would be an administrative or ancillary activity. So basically, we're getting down to collecting premiums, remitting them to the insurer, setting up the plan, establishing the plan year. This is all very basic information, very basic functions. The employer shouldn't be doing much more than this. The idea is also some of the cases have focused around employers spending a lot of time publicizing the different programs. And publicizing goes just beyond, handing out the flyer, handing out the information. These are situations where the employer will actually include it in their annual enrollment presentations and talking about the different programs. And spending a lot of time sending out email notices or email blasts. Hey, this is new and it's available. Here's what you need to do to sign up. Contact us with any questions. Once you start down that path, it gets a little bit trickier for the employer to say, oh, well, we're not really doing anything other than making it available. That's when you start to publicize it. So again, it depends on the court, it depends on the jurisdiction and the past case law. The other thing that employers need to be wary of is that they're not receiving any type of compensation from the insurer, that there aren't any kinds of rebates that are being handed back, there aren't any other types of kind of consideration that's coming back to the employer. The whole relationship needs to be, we've made this available, we're collecting the premiums, and the insurer is permitted to, reimburse the employer for any kind of reasonable expenses, that are incurred in the process of doing, collecting and remitting. The safe harbor really doesn't provide a lot of guidance on this point. However, there is analogous guidance that's available for IRA contributions that are made by employers. So actually, it's a similar type of safe harbor in the DOL regulations, but it just applies to IRA contributions. And basically, again, it's reasonable compensation for services actually rendered. So as the employer, if you've had to go to a certain expense to get everything set up for the payroll deductions and remittances, then that could be something the insurer could reimburse the employer for. But beyond that, it's very important to make sure that, there's really not a lot of funds flowing the other way. One area of caution is some courts have looked at when employers use the same insurer or broker for their plans. So say you have an insurer, you're working with your insurer, and you have life, you have disability, and you have AD&D, and they're all from the same insurer, and you treat these all as ERISA. All of a sudden, you're going to add in a couple more voluntary plans that are from the same insurer or from the same broker, but you're going to treat these as voluntary. Some courts have actually brought up the point that there may be employer compensation in this mix because there is a concern, or at least a perception, that there is a lower cost or a lower opportunity cost that's available to the employer by using all of the benefits from the same insurer or from the same broker. Whether it's actually the case is another question, but it has been brought up in different types of case law. So it's just something to be aware of. And again, none of these factors are absolutely set in stone determinative, but it can be a mixture of the facts and circumstances which could push the plan from being voluntary to ERISA, depending on which factors are more strictly adhered to. My favorite part is the not engaging in impermissible endorsement, which I would have to say is the most problematic factor for employers to follow when it comes to voluntary plans. One of the main reasons comes down to the fact of, hey, we're providing a valuable benefit to the employees. We've put time and energy into this. We want to make sure they know this is available. We want to take this off of their desks. They don't have to worry. This is a great plan. And that's where the Department of Labor says, hold the phone. Not even general enthusiasm. And I have it right here. Opinion letter 9423. In one of the footnotes, discussed a plan where the employer appeared to have endorsed a group-type insurance program because they expressed to its members positive normative judgment regarding the plan. Okay? And in the footnote, it's that communications to participants or members that state that the employer or employee organization is enthusiastic about the program is an endorsement. So, you can get excited about these plans, just keep it in your office. But seriously, beyond that, there are other factors as well that can factor in on this one. Even though you just make it available and you provide it, that's okay. Slight enthusiasm's okay.
So if I have a new hire and I provide them a folder or a binder of materials, can I include the information about the voluntary benefits in that?
Yes, you may.
Okay.
Can you include it as
Question
part of?
I've been getting.
Yes, you can include it in your benefits. You can include it in your open enrollment, in your enrollment materials. How you include it is the key, because the idea all comes down to what is the employee's perception. Is this just something that's on the table and available, or is this something that the employer is really pushing as something that they're excited about and want employees to take up?
So one of the things that I've seen often is that the employer will put his or her, or the insurer will actually put the company's logo on the pamphlets.
Logos are a no-go. So that's, oh goodness, yes. Other things as well, which were surprising to me, assisting employees with claims and appeals. You know, the insurance law and insurance claims and appeals procedures, as everyone knows, they're not exactly easy. They're not exactly clear-cut and straightforward. Helping employees, why not? Well, because you're giving them the perception that this is, again, a benefit that is being offered and promoted. So this chart, we're not going to go through it in every detail. This is for you to take away and look at a later time. But the idea is that employers really need to be thinking about what kind of treatment they're going to give these plans when they're being offered. Either side works, and we'll look at that in a moment. The important thing, I think, in the middle is this gray area. The safe harbor requires strict compliance. So if you're not sure that it's going to fit into the safe harbor category, it's likely going to be ERISA. So you need to be able to demonstrate that it satisfies the safe harbor. But I think beyond the legal determination, you also need to consider administrative impact. You know, do you really need to be satisfying the requirements for voluntary plans? Do you already have a wrap plan in place? Would it be simpler to wrap it into your wrap plan and just treat it as ERISA? Or is it something that, that the employer has the ability, the bandwidth, the internal and the external support to ensure that this product is being offered in a way that's ERISA compliant? This gets a little trickier. It's important to remember Cobra could still apply to voluntary group health plans. And this really has to do with coming down to the Internal Revenue Code's definition of group health plan. It's not tied to the ERISA definition of Cobra, so just because you satisfy the voluntary plan requirements under ERISA doesn't necessarily mean you're out of the woods for Cobra. The thing I'll say about this is it's a case-by-case determination, but you really want to be careful on making sure that, that you're not creating additional Cobra compliance risks on the code side. Some of this risk can also be mitigated concerning whether or not there's a conversion opportunity at the end of this, or that the premiums are not discounted due to the employment relationship, because the code really looks at, is the employee getting this at a discount? And then that kind of ties it into whether or not Cobra needs to be offered. But above all, it's important to perform this analysis early. We all know that ERISA, Cobra, FMLA, all of these types of penalties can add up, especially if there's a miscategorization. So it's really important to kind of do that analysis at the outset.
Well, and I think also on a continuing basis, not just at the outset, but to the extent that you're making changes, looking at that particular issue over and over again.
Exactly. On a similar note, but this is just kind of a footnote, outside of the, kind of leaving the voluntary plans, we've noticed an uptick in the last year or two in Cobra notices, specifically Cobra election notices cases. Most of these are coming out of the 11th Circuit in Florida. And it just indicates that more and more attention is being paid to Cobra election notices and the required content. The two cases that are listed here, Bryant versus Walmart stores and Gilbert versus SunTrust banks, basically both of these cases come down to the question of whether or not that Cobra notice that was provided to employees actually satisfied the requirements of the DOL model notice, whether or not they were easy to read and easy to follow. The Gilbert and SunTrust Banks case, which recently settled, contained one of the main questions, one of the main issues as well, is specifically identifying the Cobra administrator. When looking at these Cobra notices, one, it's easy to look at them and say, okay, we know where this is going. We do the employee benefits speak. We know how this works through our company. We know who this goes to. The question is, you know, these cases try to get down to the question of, are these notices explaining to employees how to get through the administration easily? Where do they look for the information? And is it explained in a manner that is calculated to be understood by the average plan participant? So, by making sure that the notice contains, more detailed instructions occasionally, if you have to go to the intranet, or if there's a specific office to call, adding those additional details may definitely be helpful. Another thing, too, is making sure that you're not only incorporating language from the model notice, but also incorporating all of the information that's in the regulations themselves. The Cobra Notice regulations under ERISA contain a detailed list. Most of this is incorporated in the 2014 model notice, which provides employers with evidence of good faith compliance, but not everything is in there. Specifically one item, and that's ensuring that there's information about how spouses and legal guardians can elect coverage for other qualified beneficiaries. The other final thing to point out is that there are a couple cases also from this circuit that are bringing up whether or not it would be required for employers to provide model notices in foreign languages when you have a substantial number of your employees who speak a certain language. In the Velasquez versus Marriott International and the Valdivieso versus Cushman and Wakefield, the question arose. Cobra doesn't require it, but based on our employee population, wouldn't it be helpful and necessary and, understandable?
So Holly, Tim Goodman talked just at the previous session about the new claims procedures and the requirement to provide notice in another language if 10% of your employee population in a specific area speaks one of these languages. Is that the standard that you're looking at in this?
Actually, the problem is these regulations were written in 2004. It's still required that there's still no requirement for employers to provide these notices in Spanish. It's still not a requirement, but these cases are coming up in that exact context. There's more attention being paid to making sure that multilingual notices are being provided. Furthermore, the Department of Labor does provide a Spanish translated model notice for employers to use and build upon. So it's something to keep an eye on in the coming months.
Okay. So this next topic that I'm going to be talking about is actually sort of a riff off of what Holly has just been talking about, which is having notices that are understandable and helpful to employees. And I don't know if you've read about this, but earlier this year, the Advisory Council on Employee Welfare and Pension Benefits submitted a report to the Department of Labor on the effectiveness of health and welfare notices and disclosures. And I'm sure that you will be shocked to realize that their conclusion was that mandated disclosures currently do not address the underlying statutory purpose of providing important information in a usable framework, and they are burdensome for plan administrators. So, how many of us have really struggled, for example, with our summary plan descriptions? We want to be able to tell everybody what their benefits are in a clear and concise manner so that the employees know what they're entitled to. But at the same time, we have all of these legal compliance requirements, and we also want to make sure that we're complete, that we haven't failed to provide the important information that this one particular participant needs to get a benefit from the plan. So there's this sort of clash of interests that we have when we're providing some of these notices. So, this report, and I have a copy of it here if you're interested in it, it's 30 pages long, and it has a couple of recommendations for the Department of Labor, and my fingers are crossed that the Department of Labor will actually look at some of these suggestions and take action. So the first one that I wanted to talk about is a safe harbor annual quick reference guide. And it's intended that this guide would be used instead of updated SPDs, SARs, SMMs, those kinds of things. The concept is that this guide would be distributed annually to participants with their SBCs. Now, you do have to continue to update your SPDs on a 5 or 10 year basis, and you do have to continue to give them to people when they're initially eligible for your plan, but you don't have to continually republish, reprint, and distribute those SPDs, which is nice. I mean, that can be a very expensive proposition if you're doing it on a hard copy basis for people who don't, for example, use a computer at work. So that would be a great thing. The DOL, they've asked the DOL to publish an example, but the report actually comes up with an example, which I think is pretty interesting. Some of the things that are in this guide, they've asked that it notify participants annually that the Form 5500 for the previous year was provided and where you can get a copy of it. And so that's sort of the alternative method for complying with SAR requirements, to the extent that you have plans that are still subject to the SAR rule. Excuse me. Identify for participants annually each material topic described in the remainder of the SPD, including where and how to locate a copy of the text for each topic. So you could say, do you want to know if you're vested in your benefit? Vesting is a concept that you're entitled to benefit when you terminate employment. Now, that's generally speaking a retirement plan idea, but the concept is that then you say, okay, vesting is in this section of the SPD on this page. So that would be nice. And then inform participants annually of each material modification of benefits that was made within the last 12 months. So that takes the place of an SMM. So that would be great if we got something like that, I think. The second recommendation was to permit us to provide annual required notices, like the WICRA notice or the CHIP notice, to have that be consolidated into one notice that's furnished during open enrollment or when somebody first becomes eligible. And, you know, a lot of us have actually sort of gone to that model now, that when you look at your open enrollment package, you have all of the legal notices together. But this goes one step farther, and this is what Hallie was talking about, having a notice that's readable and understandable. They talk a lot about legalese in this particular report, and they would like to abolish that to the extent possible. So we'll see if that happens. And then the third point, and I think this was interesting because this particular point was not in the initial purview of the report, but every expert who came and made testimony on the notice efficacy actually said, you know, we really need electronic notices. We're in the 21st century. Please, Department of Labor, update your electronic delivery rules. And so I think a lot of us here would be really happy if that happened too. So this is a case that actually our first panel talked about this morning, and they talked about it in terms of a fiduciary duty breach that the court held the insurance company and the company, the employer itself, had engaged in. Again, this is the case where the employee properly enrolled her son in an optional AD&D and life insurance policy with the employer, and when the child turned age 23, did not unenroll or disenroll the child. Now, again, the plan document and the SPD were clear, crystal clear about the age limitation and the requirement for the employee to come to the employer or the insurance company and say, hey, my kid isn't eligible anymore, and to stop paying for premiums. Unfortunately, the child died in a car accident, and the insurer denied the claims, and the premiums were refunded. That was basically her reward for paying premiums all these years. Now, the employee claimed that she didn't know about the age cutoff and that the employer was aware of the child's age due to information provided from medical coverage. So, as Andrew and Kirsten talked about, the court held in favor of the plaintiff. I think she was a very sympathetic plaintiff, but I thought that it was interesting. It says the plan and the SPD were clear, but there was this breach of fiduciary duty to the employee. They talked about how easy it was to add an age screen to the enrollment materials to make sure that participants knew when employees' dependents were aging off of plans. And they also really disliked the idea that there was a windfall to the insurer that only came about into knowledge because a dependent died and was ineligible. So they thought that really wasn't fair. But this is where I sort of shook my head. the court said, the employee did have some responsibility to read the plan in the SPD, but that didn't matter. They said the plan and the SPD were long. They were 75 pages and 25 pages respectively. Does that not sound like a lot of our SPDs and plan documents? And this is a quote: "Life is busy, and it's human nature to overlook details like this age ceiling." So, I think that, to me, for us in this session, the administrative tips are, really, if you have information that would be helpful to your employees, especially in this day and age of big data, can you use information that you have to help them so that they're not paying for benefits that they're not eligible for and they could never get? Those types of things. So. And we had to have at least one ACA slide. We've been talking about ACA for I don't know how many years. I can't even remember when ACA was promulgated anymore. But I think that some of us are now getting letters from the IRS telling us that we owe an employer shared responsibility payment. And in fact, I just read recently that the acting IRS commissioner just told a House committee in April that the IRS had sent out 10,000 approximately penalty assessment letters, and more than 80% were resolved with 0% due. So the letters that you're getting from the IRS, you should definitely look at. Make sure that you really agree with them that you have a penalty due and owed. And make sure that you do that quickly. I think there's a 30-day turnaround time. And I worry about, especially big employers, where mail comes into, one spot, but the information needs to go over here so that you can actually respond. I'm not entirely sure how you do that within each of your organizations, but make sure that those people would know to give to you guys these letters that you're getting. So if you have questions about what to do when you get a letter, the IRS website has 2 notices to help employers understand the correspondence that they might be getting. And the links to those particular notices are on the screen right now and in your materials. The first one is something that helps you understand your letter 226J, and that's the initial letter that you might get from the IRS to tell you that they think that you owe them a penalty, and it will help you figure out if you agree with that assessment, how to pay it, and if you disagree, what to do to tell them why you think that that's not right. And then there's also a notice for understanding your letter 227, and there are 5 different letters 227, and those are sent to employers to close an inquiry about a penalty assessment or to ask for further information or actions due. So I think that's all the time we have right now. We have like 2 minutes if anybody has a question, but other than that, I'm so glad that you could make it today, and we look forward to seeing you at the 4th annual seminar next year. Thanks.